Hi there, I'm James Dapperchi, and this is Coffee and a Case Note. Team, we are going to have a chat about when a contractual term is void for uncertainty. Sounds a little bit fiddly, but when we talk about contract law, what you often find is that things get pretty exciting pretty quickly. Okay, we have got a number of loan documents. Now these are back-to-back unsecured loans that are repayable on demand between entities that are related to each other. A bit fiddly, I know I hit you with a lot of words there, but essentially we're dealing with relationships with some financial complexity in a not particularly small family trust sort of circumstance. So we've got some slightly fiddly entities and some slightly fiddly relationships. That's probably a good enough background as any. And the terms of these loans are that the loans are repayable at such times, in respect of such periods, and at such interest rates as may be selected by the lender of the money. So can I get that nice and firmly planted in your head? The lender of the money gets to choose when the loans are repayable, for what period interest on the loans is payable, and what that interest rate is. So there's an element where, and the basis of these proceedings were the suggestion that, well, that is so imprecise as to be void for uncertainty. There's no actual contractual obligation that arises from terms that are so broad along those lines. So the court had to turn its mind to it. Now, the interest rate charged in relation to these loans over the years related to Division 7A, and some of you will know Division 7A better than I do, but essentially it's that deemed dividend issue, and the interest rate related to that deemed dividend issue was the one used over the life of many of these loans. The court worked through the relevant case law relating to voidness for uncertainty and found that when a court is constructing the meaning of a contractual term, of an obligation, that you weren't pedantic and you weren't overly fussed about details, but you took in mind the broad commercial context of the relationship in order to figure out whether a term was so void, was so uncertain as to be void for that uncertainty. And here the court found that because there was either an express or implied term of reasonableness about the way the lender had to go about this operation, because the relationship between the parties was close, and there was even contemplation that accountants would be brought in to work through these numbers and figure out precisely how the loans ought to operate, and because there was an obligation of honesty as well, that there was enough meat in the obligation on the lender to determine the time, the period, and the rate in respect of those loans, such that the term was not so uncertain as to be void. So, quick one today, mercifully quick you might say, and hopefully a bit of an insight for you into when and when not a contractual term might be so uncertain as to be void. Thank you kindly for joining me today, and I'm really looking forward to another coffee and another case note with you soon. Hope you'll join me then. Cheers.